This is the last part of the lecture series on the topic of interpretation of Section 6 of the Hindu Succession Act 1956. We are discussing this topic on the background of judgment given by the larger bench of the Honorable Supreme Court in the case of Vinita Sharma versus Rakesh Sharma. So accordingly, in this case of Vinita Sharma, the 3 judges bench has held as under. First point, the provisions contained in substituted Section 6 of the Hindu Succession Act 1956 confer status of co-partner on the daughter either born before or after the amendment in the same manner as son with the same rights and liabilities. So even though any daughter has been born before the Amendment Act or after the Amendment Act, she will get status of co-partner. Second point, the rights can be claimed by the daughter born earlier with effect from 9 September 2005. That means even though any such daughter has been born before the 9 September 2005, she can claim her right as a co-partner only from 9 September 2005. That means on that day, on the 9 September 2005, she must be existence, daughter of co-partner, for claiming her right. She can claim those rights with savings as provided in Section 6, subsection 1, as to the disposition or alienation, partition or testamentary disposition which had taken place before the 20th December 2004. So whatever disposition, alienation of the co-partnership property has been effected in that family before the 20th December 2004, it will remain unaffected by this substituted provision of Section 6. Third point, since the right in coparcenary is by birth, it is not necessary that father co-partner should be living as on 9 September 2005. So this is very important point, because in the earlier case of Prakash versus Fulvati, it was held by the division bench of the Supreme Court that father co-partners must be living on 9 September 2005, then only that daughter can claim her right. But in this case of Vinita Sharma versus Rakesh Sharma, it is made clear that since the right in the co-partnership which the daughter has got, since the right in co-partnership is by birth, that is by reason of her birth in the family, it is not necessary that father co-partner should be living as on the 9 September 2005. Then the fourth point observed by the Supreme Court in this Vinita Sharma case, the statutory fiction of partition created by proviso clause to earlier Section 6 of the Hindu Succession Act as originally enacted did not bring about the actual partition or disruption of coparcenary. It means that after the commencement of the amended provision, when any co-partner claims a partition against other co-partners, then those other co-partners cannot take a defense that because of the death of any co-partner before the 9th September 2005 in their family, there was a notional partition, and so now coparcenary doesn't exist. Such kind of defense cannot be taken because that statutory fiction of partition did not bring about actual partition or disruption of coparcenary. The fiction of notional partition was only for the purpose of ascertaining the share of deceased co-partner when he was survived by a female heir of class 1 or by male relative of such female. So when the proviso clause of that earlier section 6 comes into picture, then for the purpose of devolution of undivided interest of that deceased co-partner, we have to find out the quantum of his undivided interest. For that purpose, we have to take help of notional partition, we have to take help of this fiction, but merely because there was a notional partition, it doesn't bring about disruption of coparcenary. So coparcenary still exists. The provision of substitutory section 6 are required to be given full effect. Notwithstanding that a preliminary decree has been passed, the daughters are to be given shares in coparcenary equal to that of son in pending proceedings for final decree or in an appeal. So merely there is a fixation of share by a preliminary decree, then also when the statute get amended in the pending proceeding, while the proceeding is pending in the court, daughters are entitled to claim their right as per the amended provisions. The next point observed by the Supreme Court, it is regarding the recognized mode of partition which is provided under the explanation clause to subsection 5 of section 6. The recognized mode of partitions are only two, that is deed of partition duly registered or partition effected by a decree of court. So court observed that a plea of oral partition cannot be accepted. A plea of previous oral partition cannot be accepted. But to that also there is one exception. However, in exceptional cases where such plea of oral partition is supported by public documents and partition is finally evinced in the same manner as if it had been effected by a decree of court, then it may be accepted. But a plea of partition merely based on the oral evidence alone cannot be accepted, and it is to be rejected outrightly. So in this manner, 3 judges bench of the Honorable Supreme Court in this case of Vinita Sharma versus Rakesh Sharma has overruled the findings given by the division bench of the Supreme Court in the case of Prakash versus Fuloti and in the case of Mangalam versus T.V. Raju. And in this case, the Supreme Court partly overruled the opinion which is expressed in the case of Dhanamma versus Amar, which is to the extent which is contrary to this present decision. So here we have finished this topic of interpretation of section 6 of the Hindu Succession Act. Thank you very much for watching for my all videos. I expect that it will get benefited to all the legal professionals, especially junior advocates. I expect from all the juniors that they should refer the Bare Act, they should read the word-to-word actual provisions in the statute, they should also read the relevant case law from the law reporters, and I request all of you, please give your like, comment to my videos, please subscribe my channel, and please refer the these video links to all your friends who are belonging to legal profession. Thank you very much.